Welcome to my wills review for my Wills, Trust, and Estates class. We'll start with intestacy. When you die without a testamentary instrument, and that can be a trust or a will, in order to determine how your estate passes, you'll have to go to the statutes your specific state has developed to handle the situation. We'll focus on California since that's the focus of this class. In California, for example, if you have a spouse remaining, so a surviving spouse after you pass, but no children, parents, or siblings, that spouse gets everything. This is true even if you have children and no spouse, parents, or siblings, the children get everything. Parents, but none of the other three, the parents get everything. And finally, siblings. If you have siblings but no spouse, no children, or parents, the siblings get everything. Now, if you have a spouse and children, it depends on how many children you have. Since California is a community property state, the spouse is going to get all of your community property, you've passed away, and half of your separate property. And if you remember, community property is combined of that property you have since you've been married living in California, plus what California calls quasi-community property. And that quasi-community property is whatever property you may have acquired while married, so after the day you were married, but living in another state. And that can be a non-community property state or a community property state. Doesn't matter. They call it quasi-community property. It's treated like community property when you come to California. Now, that separate property, if you recall, is the property you got through gifts, through inheritance, or before you were married. Now, if you have one child, then the spouse is only going to get half the separate property. If you have more than one child, then the spouse is going to get 1/3 of your separate property. But in both scenarios, the spouse is still getting all of the community property. If there's a spouse and parents remaining, but no children, the spouse gets all the community property and half the separate property. The same holds true if you have a spouse and siblings, but no parents. And this intestacy system continues on, but this is the basics, and this is really what you need to understand. Now, if the descendants have issue, this becomes a scenario where you've got children, but no one else is remaining to make it easy. And one of those children has passed, but left their own children, your grandchildren. There's three ways to handle this: per stirpes, per capita with representation, and per capita each generation. Per stirpes goes by, it looks at the stocks. You're going down the lineage. So for example, we'll just say you have three children, A, B, and C. B has passed away. B left two children of their own. If all three children were still alive, each would get a third of a share. So a third, a third, a third. Real easy. What happened since that middle child passed away is that third the middle child would have received drops down to the grandchildren and is split in half. So a sixth and a sixth. There's also what's called per capita with representation. This is referred to as a modern per stirpes model on occasion. This is kind of a combination of the per stirpes and the per capita world. The main difference with the per capita with representation versus per stirpes is instead of starting at that first line of children, it may drop lower. Here's an example. Our first example of per stirpes showed you pass away and you leave three children. That's where the representation is going to start for determining where the assets are going to go. Let's assume that you pass away, your three children have died, and you left with 5 grandchildren between your 3 now deceased children. If you were using per stirpes to determine how much of a share those grandchildren was going to get, you would simply look at that first level where they're all deceased, those 3 children, and that's the stock that's going to represent and show where those assets are going to go. So regardless of whether that first generation is alive or dead, they're still the determining factor. With per capita, that's not the case. You will drop down until you find the first level of living issue. Like we said, you've passed away. Your 3 children passed away before you. You're left with 5 grandchildren. That is the level that will determine the representation. So now, instead of having the 1/3, 1/3, 1/3 for each of those 3 deceased children, we're looking at that level of 5. So now it's a 1/5, 1/5, 1/5, 1/5, 1/5. Each one's getting a fifth. If one of those grandchildren has passed away and left issue of their own, their share of that 1/5 drops down to the great-grandchildren of that issue and are divided depending on the number of great-grandchildren there are. This leaves us with the per capita each generation. Just like the per capita with representation, you're going to start with the first line of living issue. Back to our example, you've got 3 children, they've all passed away. We've got 5 grandchildren. At least one of them is alive. That's the level at which they're first going to determine how assets are going to be divided. So we've got these 5 grandchildren. We'll assume 2 of them are alive and 3 of them have passed away. The first one who passed away left 1 great-grandchild. The second one who passed away left 3 great-grandchildren. And the third one who passed away left no great-grandchildren. So you've got the 2 remaining living grandchildren. The way it's going to play out is each grandchild would have gotten a fifth because there were 5 of them. So the 2 living each get a fifth. The remaining pool of money is going to drop down to that next level of issue, the great-grandchildren, and be divided evenly among however many great-grandchildren there are. It does not matter that one of the grandchildren had possibly 1 great-grandchild for you, and the other had 2, 3, 4, 5. They're all going to get the same amount of the inheritance that has dropped down. Now, we've dealt with intestacy and representation. Now let's actually get into creating wills. And the nice thing about testamentary capacity is that there's 4 things. Sometimes they're called 3, but we'll use 4 here. And this is what you need to have for either a will or a trust. It's the same capacity rule for both. What the testator needs is to know the nature and extent of his or her property, the natural objects of his or her bounty. Put that in plain English, we're talking about who are his or her issue, family members, things of that nature. The nature of the testamentary act being performed, and how all those relate to constitute an orderly plan of disposing of T's property. Sometimes you will see this summarized as the nature and extent of T's property, the natural objects of T's bounty, and the testator must know that they are making a will or a trust. Now, one thing someone who wants to challenge an estate may do is they'll attack capacity. They're going to want to say that the testator wasn't capable of making this testamentary scheme that they've come up with. Now, if they are successful in this, that can set aside the will, or possibly just one gift under the will. But let's just say it sets aside the whole will and dumps the whole estate into intestacy. And then it will follow those statutes like we've seen. The reason for doing this is when someone would fare better under the intestacy statutes than under the document that's actually been produced as a will or a trust. Undue influence is one you'll probably come across most commonly. It is kind of difficult to prove if you just think about what you're going into, what you're trying to prove. But in summary, what you're really looking for is that the defendant, that person who's being accused of unduly influencing the testator, has substituted his intent for that of the testator. Common elements for this are that the testator was susceptible to influence, the defendant had opportunity, the defendant had a motive, and causation. Another way of thinking about this is that the testator was close to the person influencing. Some of the cases you'll read will talk about a fiduciary relationship, so it would be a lawyer or someone of that nature. It's not always the case. It just has to be someone close. It could be a child of the testator. It can be a friend of the testator. They just need to have that close relationship. And that usually covers the susceptibility and the opportunity. The motive can be very clear. You'll notice it all of a sudden this defendant has gotten all of the assets out of the estate. And the causation, what you look for is that there was this closeness and opportunity, and there was this closeness and susceptibility that the testator had to influence, and the defendant's actions on that led to the outcome. Insane delusions. This is where you have a false perception of reality that the testator adheres to against all reason or evidence to the contrary. With regard to insane delusions, the majority of states actually find that any factual basis to support the belief is good enough. It doesn't have to be a reasonable basis, it just has to be any factual basis you can come up with that will support this delusion will be good enough to survive any attack on capacity using insane delusion. Duress and fraud. You should be familiar with these from contract law. Duress, as we all know in our heads, is someone holding a gun to someone's head to make them do something. Doesn't necessarily have to be that extreme. To put it simply, it's where the defendant performs or threatens to perform a wrongful act that causes the testator to make a transfer the testator otherwise would not have made. So this is an easy one if you want to look back. Look at what's happened, what the testator has done with the estate upon death or upon the execution of the will, and look back and see what's happened after that would have forced the testator to do that. Fraud. Intentional misrepresentation made knowingly and purposely to influence testator's testamentary scheme, causing the testator to transfer his property in a way he otherwise would not have. There's two types of fraud. You have inducement and execution. The easiest one to remember is execution. That's going to be a scenario where someone is either blind, can't read, doesn't have time to read, something along that nature. And the defendant, the one who has engaged in the fraud, will put the stack of papers in front of them, say that this stack of papers is merely an invoice or something like that. It's actually a will. The testator signs it. And there you have it. You've got the testator did not have the capacity to actually complete this testamentary transfer. Inducement. This is where you're going to have a factual misrepresentation that leads to the inducement of the execution of the document. An example of inducement would be you've got two sons. One of your sons decides to take you on a trip, convinces you that the other son has run away with all your money, and at that point you decide to create a new will where you're going to disinherit that son who allegedly ran away with all your money, when in fact that son has done nothing of the sort. That's what you're looking at for inducement. Now, remedies. If there is going to be a problem with your will or with the capacity, there are some remedies you can get. There's a constructive trust. For example, in that case where we had the fraud by the inducement, where one of the sons convinced the father that the other son had run off with the money and that really wasn't the case, it may be possible to have a constructive trust set up, and whatever share would have gone to that second son held by the first son as trustee until it can be passed to the second son. Undue influence, you commonly see damages. You can see attorney's fees under undue influence and costs. Tortious interference. This doesn't occur in all states, but some states, including California, have the tortious interference with the expected inheritance tort. In order to prevail on this, the plaintiff has to prove the existence of an expectancy, a reasonable certainty that the expectancy would have been realized but for the interference, intentional interference with the expectancy, tortious conduct involved in the interference, such as fraud, duress, or undue influence, and damages. This would be a very good cause of action if you're taking an exam and the issue of fraud, duress, or undue influence came up. You discuss fraud, duress, and undue influence, and then once you were done with that, you would include this one. Now the will formalities. If you have an attested will, the following formalities are necessary. The will has to be in writing, signed by the testator, and witnessed by 2 witnesses. With regard to the witnesses, depending on your jurisdiction, they may have to be in direct sight of each other as well as the testator when everybody's signing. And the testator has to sign first. They'll sign after. Other jurisdictions, conscious presence is good enough. As long as you know, as a witness, what's going on, you don't have to be in direct sight. This becomes an issue in a lot of the hospital cases you see, where a hospital employee will be one of the witnesses. They have to step out to see a patient or take a call. The signing process is underway. They know what's going on in the room, but they're not directly seeing it. Conscious presence will protect the whole process in that scenario. But if you're in a jurisdiction with direct sight, that's not going to be good enough. You've now got a improperly executed will, which is open to contest. If they decide to contest it, then you may end up with intestacy. The other thing that comes up with witnesses is disinterested. Do yourself a favor and always use witnesses who are going to take nothing under the will or trust or whatever you're dealing with. Makes life so much easier. It's kind of common sense. If you do have an interested witness, there is a way around this. If you've got 3 witnesses, so you need 2 disinterested if you're going to have an interested. In that scenario, you've already got 2 witnesses. Why include this interested person in the process and muck it up? because there are some states that will look at that interested witness, even though there's three and two of them are disinterested, and say, you know what, interested witness, you take nothing. It gets a little more complicated as things go down the line if you look at what was given under the will, but make it real easy. And when you see a question on an exam, if there's someone who's going to take under the will, make sure you raise that issue of disinterested and interested witnesses. Holographic wills. Not all states have holographic wills. California does. A holographic will is usually in the testator's own handwriting, the whole thing, not always. California allows for the use of a form for the non-material provisions. This depends on the jurisdiction. Some jurisdictions require the whole thing to be handwritten. The parts of the holographic will that must be in writing, in the handwriting, are the material provisions, so what's going where. It needs to be signed in your own handwriting, and it has to show testamentary intent. Now, the signature need not be at the end of the holographic will. It depends on your jurisdiction, but as far as we've noticed in California, it can be anywhere. And there's no witnesses required because it's in your own handwriting. Now, let's talk about signatures for a second. We saw that the testator needs to sign in an attested will as well as in a holographic will. What counts as a signature? A signature can be anything that testator commonly uses as their mark of identification. If the testator uses an X will do. It's whatever they're going to use. Codicils. These are testamentary instruments used to amend a will. If you remember them as that, life stays easy. There's some other jurisdictions that will change it up a little bit. But what a codicil does is normally it republishes the will as of the codicil's date. So you've made an amendment. Usually you've changed a gift in there or maybe added a specific gift or bequest. When that codicil is completed and signed and witnessed, just like under any attested will, or if you do it in your handwriting, make a codicil fully in your handwriting. Now it's a holographic document, so it doesn't need the witnesses. It republishes the will as of the date of the codicil. This gets a little confusing because there's certain times when the court will look at it and say, you know what, it really doesn't republish at that date. And we'll see that a little bit later with revocations and things of that nature. But just go with, normally it's going to republish the will as of that date. And that becomes an issue when you deal with children that possibly were born after the date of the will, but before the codicil. In that case, it's very possible that the child, if they weren't mentioned in either document, may not take, because now instead of being a pretermitted child, being one that was born after the execution of the original will, now they are one that was born before the execution of the most current will, that being the one that the codicil is republished. And with regard to holographic, you can do a holographic codicil to amend an attested will. And you can do an attested codicil to amend a holographic will. You're not stuck staying, you don't have to pick a lane and stay in it. You can cross lanes and move from attested to holographic back and forth. Scope of the will. Doctrine of integration. It's really easy. The pages that are physically present at execution that testator intends to compromise the will or to comprise the will are part of the will. Incorporation by reference, we've talked about this. If you have an external document you want to make part of or reference to in the will, you have to have that document completed at the time or before you're executing the will. Best example, pour over wills. When you do a revocable trust, you will more than likely want to have a pour over will in case something is left out of the revocable trust. That way, when you pass away, whatever's left out can make it into that revocable trust. In that pour over will, you're going to make an explicit remark naming that revocable trust, and that revocable trust should be in existence at or before you executed this will. Independent significance. This is where a will may dispose of property by reference to acts outside the will. For example, there's 3 ways this can go down. I give all the property in my house to my brother Doug. Well, that property, that personal property in the house can change. It could be one thing today when I execute the will, and it could be completely different because I might buy things between now and the day I die. I might take things out and sell them. So whatever's in the house at the date of my death is what it's going to be. So that can change throughout life after execution of the will. I give $10 to each of my sons-in-law. I may have several daughters. They may not have been married at the time I executed the will. They may have been married, gotten divorced, and gotten remarried. So sons-in-law may change throughout my life before I die. And then you have the tangible personal property memorandum. And this is one you will commonly see. What this does is there'll be a paragraph in the will that says, I'm going to make a personal property memorandum listing who's going to get certain things when I pass away. Those things have to be tangible personal property. So stocks and bonds are intangible, so that doesn't count. We're talking rings, furniture, jewelry, things like that. Cars. Things that are personal property, something you can actually touch. Now, revocation. There's 4 ways to revoke a will. You can do it by act, you can do it by writing, you can do it by presumption, or operation of law. With act, that is where you tear up the will, burn the will. You are destroying the will. But you have to have intent at the same time that you want to revoke this will. If you just show up one night, tear up your will for no reason other than you just felt it was fun to tear up a will, that does not revoke the will. An act actually can include writing, as long as the writing is across or involving the words of the will. If it's in the margin, that's likely not going to count. It's going to have to actually cross out or write across, as in void, across the language in the will. You need the intent along with that, but that's an act you can do. Revocation by writing, the way you do that is actually by creating a new will. That's really what that means. Revocation by writing, create a new will, revokes the last will or the previous will. Presumption, there's a presumption that if you've lost your will, then it's been revoked. The way this works is you look at the will had to be in the testator's possession the last time anyone knew, and it could not be found after the testator's death. This is rebuttable, but if evidence isn't brought forth to show the testator did not revoke the will, then it's going to be presumed revoked, and the intestacy statutes will kick in. Operation of law. This will be statutory. The most common one is upon divorce. Your ex-spouse immediately drops out of your will, even though the will says everything's going to your wife or husband. The minute you're divorced, it acts as if they've predeceased. The only exception to that is if you've expressly placed in your will that this will survive a divorce. Dependent relative revocation, DRR. If a will is revoked in whole or in part based on a mistake of fact or law, and the testator would not have revoked but for the mistake, revocation will not be given effect. A common example of this is where you've got a testator who's devised $1,000 to his daughter. He says, you know what? I want to up that to $2,000. Puts one line through the $1,000. Above it writes 2,000. What happened there was a revocation of the $1,000 devise. He intended to revoke it because he wanted it up to 2,000, and he engaged in an act, the crossing out of the 1,000. So right there you have your revocation by act, another example of it. When that happens, the dependent relative revocation doctrine kicks in, looks at this, and sees that the testator made a mistake of law, thinking that this is how you can update your will. And had he known that that's not how that would have played out, he would not have engaged in that conduct, and the revocation won't be given effect. So in this case, the daughter, who is going to get the $2,000 if the testator would have properly done what he was trying to do, instead of getting nothing, will actually get the $1,000, because that $1,000 that was originally revoked is now deemed to not have been revoked. Revival. Like we said, when a second will is created, the first will is revoked. That's revocation by writing. If the testator's intent can be shown that upon revocation of the second will, that the first will should be revived, then the first will is revived. Now, if the revocation of that second will is done in writing, the third will must state the intent to revive the first will. It's got to be clear. Now, if the revocation of a codicil will automatically revive the original language in the original will, that will work. So when you look at codicils and those are revoked, the underlying will language comes back to life. This is one of those tricky things where you look at the codicil as republishing the will, but then when it comes time to revoke the codicil because you decide you want to go back to the original language, all of a sudden the will is treated as if the codicil had not actually republished at that date. Now, bequests. There's 4 types of bequests, otherwise known as gifts. You have a specific, a general, a demonstrative, and a residuary. The specific gift is really easy. It's I give a specific item to whomever. For example, I give my 10 shares of XYZ stock to Joe. It's very specific. I got 10 shares of XYZ stock at the time I execute this will. That's where it's going. The general gift is of general pecuniary value. It doesn't matter where it comes from in the estate. Just I give $10 to my brother. It doesn't matter where that $10 comes from, as long as we can grab $10 somewhere. Demonstrative gifts are similar to the general gift, except they actually come from a specific source. It's kind of a merging of the two. For example, I give $10 from my Wells Fargo savings account. Now, this might get confusing, where if I execute my will and I have a Wells Fargo savings account, and Wells Fargo gets taken over by another bank, and my savings account's no longer Wells Fargo, it's a different. But we can trace that and keep that gift alive. And then you have a residuary gift. This is a gift of all the property you haven't previously devised. Anything you own that has not been devised at this point drops into this residuary estate. If you want to think of it as a bucket, put it in the bucket, and it all goes to whoever you've given it to. One place you'll see the intestacy statute show up is where a residuary bequest fails for some reason. That fails, we have a bunch of stuff out there, intestacy is going to kick in. common law for redemption was very harsh. Now, to start with, if you really worry about redemption, all you have to remember is that the only time redemption comes up is if it's a specific bequest. That's that bequest of some property I've had today as I execute my will. I die. If that property is still in the estate, it's going to whoever I said it goes to. If it's no longer in my estate when I die, it's deemed to be deemed. When that happens, that beneficiary takes nothing. They're out of luck. It's irrebuttable under common law. California, however, looks at the change in form of the gift. They're going to look at the intent of the testator. Here's an example. I have 100 shares of Disney stock. My 100 shares of Disney stock is going to go to my brother Robert. I execute my will. I've got the shares at the time I execute, so it's all valid. It's a specific gift. At some point during that time, between now and the time I die, I look at how the market's working. I decide to sell out of the 100 shares of Disney, and I take that specific amount of money and replace it with 100 shares of Google, we'll say, determining it just to be a better investment, right or wrong. That is a change in form of the gift. If they can show that that's what I intended, then instead of my brother Robert being out of luck because the Disney stock no longer is in existence in my estate, he will take the Google stock. This requires the tracing of funds from the sale of the asset. Like I said, it's real easy to trace however much money I got from the Disney. If I take that same amount and use it to buy the Google, that makes it real clean and easy. The issue will arise if you're tracing it and the assets that I had received from the sale of the stock, I place into another fund, for example, my bank account. And I just happen to have a specific bequest of my bank account to somebody other than my brother. In that case, my brother's out of luck with regards to the money from the stock because it can be traced. And when we got done tracing, it ended up going somewhere that was going to go to somebody else. Now, the other thing with redemption is courts commonly try to avoid it, and they'll do that by reclassifying the gift as something other than a specific bequest. They'll get real creative. So you'll read cases and you're looking at it, you're like, well, yeah, that's specific bequest. That makes complete sense. Next thing you know, the court's like, well, it's really not. It's a demonstrative gift, or it's a general. But usually they'll try to get into the demonstrative, saying that the person really meant this amount of money coming from this account. Like I said, they get creative. Lapse and anti-lapse statutes. These become an issue when you have a beneficiary who dies before the testator. So let's say we've got that Disney stock, 100 shares, that I'm going to give to my brother Robert upon my death. Let's say my brother predeceases me. The gift therefore lapses. It doesn't touch his estate, doesn't go anywhere. Now, if there's an anti-lapse statute like California has, it will save a lapsed gift by transferring the devise to the beneficiary's issue. So let's say my brother's predeceased me, he's got one child. What you'll look for are three things. That the beneficiary, so my brother, meets the requisite degree of relationship with the testator. That's pretty easy. That's, someone who's within 1 degree of me, it's my brother. That makes it real simple. The beneficiary's issue that survived the testator. Well, if he's got a son, so my nephew survives me. As long as he survives me, we're good. and the will does not expressly waive the anti-lapse statute. And what it'll say is something like, if a beneficiary predeceases me, their gift lapses. It'll be that explicit. It will just put everyone on notice that, either you survive me or you get nothing. Adopted and stepchildren. If you're an adopted child, you're on par with issue. Upon your adoption, you become a part of that new family, and you're able to inherit from that family. Stepchildren, they haven't been adopted, so they're not on par with the issue unless the testator in the will puts express language including them. What's interesting in California is stepchildren actually are included in the intestacy scheme if you get down far enough. Pretermitted or omitted children and spouses. If a spouse is omitted from a will executed before or after marriage, if you're in a common law state, the elective share of the whole estate will kick in. If you're in a community property state, a share or the share of the community property that was the deceased spouse, plus intestate share of separate property will move to the spouse who is not included in the will. If a child is omitted from a will executed before birth, then the intestate share goes to them. Unless the omission was intentional, the testator had other children and gave substantially all of the estate to the mother of the pretermitted child, or the child was provided for in an estate plan outside the will. So we'll say there's a trust outside there or something else that takes care of the child. What you're really looking for is to make sure the child isn't left on the burden of the state. So here's an example that gets a lot of people. You've got 3 children. 2 of them were born before the will was executed. They're included in the will. There's a 3rd child born after the will is executed. You die shortly after the child's birth. In that scenario, if you follow just the straight thinking behind this, what will happen is that 3rd child will get an intestate share, regardless of what the other 2 children may have gotten. Unless you've got this situation where the other children, the testator and other children give substantially all the estate to the mother. If everything went to the mom, then that forgotten child is probably out of luck with getting a direct inheritance. If for some reason there was some money that was going to be given to those 2 children, there's a California statute that will look at that, and you have to prove, if you want to try to make it go this way, that had the testator remembered that 3rd child, that he or she would have made it equal distribution among the 3. But unless you can prove that, then that one child is going to end up with an intestate share, which may be large compared to what the other 2 kids have gotten. And anytime you get this intestate share, whether it be a spouse or a child, that comes out of the estate early on. So that's going to come out before everybody else gets their stuff. Now, if a child is omitted from a will executed after birth, they take nothing absent proof of mistake or intent. Remember, in California, they are strong believers in what the testator intended. So even if we go back to the will execution ceremony, if that's completely fouled up, they can look at the testator's intent to overcome that problem. So intent is big in California. So whenever you're writing an exam and you're feeling a little light on something, you can always throw in the intent of the testator to try to overcome whatever the issue is. Now, will substitutes. There's many ways you can avoid probate, and these things will work without a will. In fact, they'll work even if there is a will. Beneficiary designations, if you list somebody on your insurance policy or your 401k or something like that, they will pass according to what you've listed, regardless of what your will says. That's just generally how it works most places. Revocable trusts, you'll use that instead of a will. You'll have a pour over will if you're with it. But the pour over will is just going to dump everything into the trust. Anything in the trust, even if it's a revocable trust, that the day I die essentially shifts everything over to the beneficiaries, that's good enough. That's a will substitute. Payable on death clauses, you'll see this in contracts. You can do it for stock certificates, things like that, stock holdings. When I die, everything automatically kicks over to whoever I've listed. I've got this listed on a real property, but it can happen in outside of real property, joint tenancy on bank accounts, things like that, same story. Now with real property, you've got joint tenancy, tenancy by the entirety, and transfer on death deeds. Those are 3 ways this could happen. The reason, even though we're focused on California law, to just understand that you've got these out there. And just so you know, tenancy by the entirety is joint tenancy, but the added element is that the joint tenants are married to each other. Think of it kind of like community property, except it's joint tenancy, where when someone dies, instead of having that estate split in half, it just automatically kicks over to the surviving tenant and they own everything. The law of the location governs. So wherever that property is held, be it in, let's say you're in California, but you own property in Utah, Florida, and Texas. Utah, Florida, and Texas are going to determine how that property proceeds through probate and how it's going to move. You can get around this by doing a revocable trust, put all that property in a revocable trust, and you don't have to deal with these ancillary probate issues. But that's why you want to know that there's just other ways to pass property. Now, with regards to your personal property, if you recall, your personal property will pass according to the state you're domiciled in when you pass away. That's the easiest way to remember it. Sometimes you'll see things they'll talk about where the will was executed, things of that nature. But normally when you see these kinds of things, they're going to look directly where you're domiciled. And so the personal property, domiciles, what matters, real property, the location of the real property.